Hi everyone, and welcome back to the Flow Migration Law channel. My name's Jay and I'm the principal migration lawyer here. Before we begin, a quick disclaimer. This video offers general guidance only. Australian immigration law is detailed and can change. If you've received a Section 58 request for more information or are unsure about your situation, consulting an immigration lawyer for advice specific to your circumstances is always recommended. Now today, we're diving into a situation that can feel a bit daunting for partner visa applicants. Receiving a Section 56 request from the Department of Home Affairs. Don't panic, but do pay close attention. While these requests are common, they can also signal that something in your application needs a closer look. So what exactly is a Section 56 request? Under Section 56 of the Migration Act, a case officer can formally ask for more information or documents. You'll usually receive this via your email account or an email that's sent to your inbox, and you'll have deadline to respond, generally about 28 days. In a partner visa context, these requests often come when documents are missing, there are inconsistencies, or the case officer just needs more evidence to properly assess your relationship. Some requests are straightforward, like a missing police check, but others can carry more weight. Let's explore 3 important red flags that might be hidden within a Section 56 request. The first and perhaps most common red flag is when the department suggests your relationship evidence isn't quite sufficient. The letter might not exactly say your evidence is weak, but it might ask you to provide further documentation about your shared household or clarify the financial aspects of your relationship. This is a strong hint that the department isn't fully convinced your relationship meets the genuine and continuing test. Some signs this might apply to you include if you mostly submitted photos and basic declarations with less robust evidence of joint finances, leases, or utility bills. Or perhaps there is a gap in your relationship timeline. What should you do? Don't just resend what you've already uploaded. You need to address the request head-on with stronger updated evidence, clear timelines, and documents that genuinely reflect the 4 pillars of your relationship: social, financial, household, and commitment. The second red flag pops up when the department isn't asking for missing items, but rather for clarifications on things that don't quite add up. You might be asked to explain conflicting travel dates between forms, differences in how you and your partner describe the start of your relationship, or variations in addresses or visa histories. Even minor discrepancies can raise questions about credibility, which is a serious issue when the genuineness of your relationship is key. My advice here is go through your original application with a fine-tooth comb. Cross-check everything. If there is a legitimate explanation, maybe a typo, or a misunderstanding, or an honest mistake, acknowledge it clearly. Explain it in writing, calmly and respectfully, with any supporting evidence you have. Now, this third red flag is less common, but it's very serious. If the department asks you to clarify aspects of your relationship that seem unrelated to the documents you provided, for example, why you're living separately, or requests for unusual personal clarification, it could mean external information has prompted a deeper look. This might be triggered by an anonymous tip-off, concerns from a previous visa, or public information inconsistencies. If this happens, it's more than likely that it's not a routine tick box exercise. Treat it as a genuine concern from the case officer. Provide the requested information, but also consider including a well-structured personal statement that offers context and background in a calm and clear manner. This is where strategic thinking becomes incredibly important. Sometimes a Section 56 request can be frustratingly vague, simply asking for further evidence of your relationship without pointing to a specific issue. This often suggests the case officer has an underlying concern, even if it's not explicitly stated. If you get a vague request, go back and recheck your entire application. Look for those 3 red flags we just discussed. Could there be an overlooked gap or inconsistency? If you're unsure what the real issue is or how to respond effectively, this is the moment to get professional advice. A migration lawyer can help pinpoint the underlying concerns and guide you to prepare a robust and persuasive response. Receiving a Section 56 request is definitely not a visa refusal, but it's also not something to take lightly. Some are routine, but others are subtle warning signs. Ask yourself, does this feel routine or does it hint at deeper scrutiny? Am I truly confident in my response? If you're feeling uncertain or need help crafting a strong response, please don't hesitate to reach out to Flow Migration Law. With over 8 years of dedicated experience in Australian migration law, I have helped many navigate these situations. You can find our contact details on our website linked below. If this video helped you, please give it a thumbs up and subscribe for more Australian immigration insights. Thanks for watching, and I'll see you in the next video.